Okay, so these are the court cases and the supplemental readings that we should know. First, we have Schenck v. the United States. The main question in this case is, did Schenck's conviction under the Espionage Act for criticizing the draft violate his First Amendment right to freedom of speech? So during World War I, socialists Charles Schenck and Elizabeth Baer distributed leaflets declaring the draft violated the 13th Amendment prohibition against involuntary servitude. The leaflets urged the public to disobey the draft, but advised only peaceful action. Schenck was charged with conspiracy to violate the Espionage Act of 1917 by attempting to cause insubordination in the military and to obstruct recruitment. Schenck and Baer were convicted of violating this law and appealed on the grounds that the statute violated the First Amendment. The court unanimously held that the Espionage Act did not violate the First Amendment and was an appropriate exercise of Congress' wartime authority. Writing for a unanimous court, Justice Oliver Wendell Holmes concluded that courts owed greater deference to the government during wartime, even when constitutional rights were at stake. Articulating for the first time the clear and present danger test, Holmes concluded that the First Amendment does not protect speech that approaches creating a clear and present danger of a specific evil that Congress has power to prevent. Holmes reasoned that the widespread dissemination of the leaflets was sufficiently likely to disrupt the conscription process. Famously, he compared the leaflets to falsely shouting fire in a crowded theater, which is not permitted under the First Amendment. Then we have the United States v. Wheeler. The main question of the case was, does the federal government have the authority to punish individuals who interfere with the citizens' freedom of movement? The industrial workers of the World Labor Union called for the strike against mining companies in Bisbee, Arizona. In response, Sheriff Harry Wheeler and other law enforcement officials kidnapped and deported over 1,000 miners, leaving them in a desert in New Mexico and prohibiting them from returning to Bisbee. The indictment against the officials responsible was dismissed, and no one was charged with wrongdoing. The Supreme Court affirmed the decision of the District Court for the District of Arizona and held that states have the sole power to prosecute individuals for wrongful interference with the right to travel. This matters because it established the U.S. Constitution grants sole power to the states to prosecute individuals for wrongful interference with the right to travel. The ruling in this case altered the interpretation of the Privileges and Immunities Clause to establish that states had the sole power to enforce the clause. Then we have Ozawa v. United States. The hardening of the U.S. isolationism and nativism set the stage for the Supreme Court to affirm the 1790 Nationality Act's prohibition against naturalization for Asians because they are considered racially not white regardless of their demonstrated acculturation and integration. Takao Ozawa was a graduate of a U.S. college and living and working in Hawaii with his family. While he was otherwise qualified for naturalization and citizenship, his application for citizenship was rejected on the basis of his race. The court concluded that the Japanese could not be white since they were clearly of a race which is not Caucasian. It also denied Takuji Yamashita naturalization case on the same day. The rulings not only cemented the citizenship status of the Asi, but gave anti-Japanese advocates the justification for the exclusionist cause, culminating in the Immigration Act of 1924. It barred all further immigration from Japan. Next, we have Moore v. Dempsey. The case involved 12 black farmers in Arkansas who were sentenced to death for allegedly killing whites during a riot. 5 white men had been killed during the Elaine, Arkansas riot of 1919. Some probably shot accidentally by other whites. Over 700 blacks have been arrested, 67 sent to prison, and 12 farmers tried by an all-white jury for the murder of whites. The case was one of the 2 lawsuits pursued by the NAACP in the aftermath of the Elaine massacre. After short trials dominated by citizen mobs, 12 African Americans, 6 who became known as the Moore defendants and 6 who became known as the Ware defendants, which was a separate case, were found guilty of murder and sentenced to death. Ultimately, the 6 Ware defendants were freed by the Arkansas Supreme Court. It took almost 5.5 years and numerous legal efforts to have the 6 Moore defendants released from prison. The 1923 U.S. Supreme Court decision Moore v. Dempsey changed the nature of the Due Process Clause of the 14th Amendment. The ruling allowed for the federal courts to hear and examine evidence in state criminal cases to ensure that defendants had received due process. Okay. Now Gitlow versus New York. The question here is, does the First Amendment prevent a state from punishing political speech that directly advocates the government's violent overthrow? Gitlow, a socialist, was arrested in 1919 for distributing a left-wing manifesto that called for the establishment of socialism through strikes and class action of any form. Gitlow was convicted under the New York's criminal anarchy law, which punished advocating the overthrow of the government by force. At his trial, Gitlow argued that since there was no resulting action flowing from the manifesto's publication, the statute penalized utterances without propensity to incitement of concrete action. The Appellate Division of the New York Court of Appeals upheld his conviction. In an opinion authored by Justice Edward Sanford, the court concluded that New York could prohibit advocating violent efforts to overthrow the government under the criminal anarchy law. Citing Scheck and Abrams, the court reasoned that the government could punish speech that threatens its basic existence because of the national security implications. Despite the small scale of Gitlow's actions, the majority was not persuaded that they were too insignificant to have an impact. Next, Pierce v. Society of Sisters. The Compulsory Education Act of 1922 required parents or guardians to send their children between the ages of 8 and 16 to public school in the district where the children resided. The exceptions included 1. Children who were mentally or physically unable to attend school, 2. Children who had graduated from 8th grade, 3. Children living more than a specified distance by road to the nearest school, 4. Children being homeschooled, and 5. Children attending a state-recognized private school. The Society of Sisters was an Oregon corporation which facilitated care for orphans, educated youth, and established and maintained academies or schools. The act was seen to infringe on the right of private schools to enroll students and conduct business. The main question was, did the act violate the liberty of parents to direct the education of their children? The unanimous court held that the fundamental liberty upon which all governments in this union repose excludes any general power of the state to standardize its children by forcing them to accept instruction from public schools only. Whitney v. California. Charlotte Anita Whitney, a founding member of the Communist Labor Party in California, was prosecuted under California's Criminal Syndicalism Act for helping to organize a group that sought to effect economic and political change through the unlawful use of violence. Whitney argued that she had not intended the organization to act this way and did not plan to aid in those objectives. She claimed the California law violated the First Amendment. We see the question emerge: did the Criminal Syndicalism Act violate the First or 14th Amendments? In a unanimous decision, the court sustained Whitney's conviction and held that the act did not violate the Constitution. The court found that the act violated neither the due process nor the equal protection clauses, and that freedom of speech guaranteed by the First Amendment was not an absolute right. The court held that the state, in the exercise of its police power, can punish those who abuse the rights of freedom of speech by utterances inimical to the public welfare, tending to incite crime, disturb the public peace, or endanger the foundation of organized government and threaten its overthrow. In other words, words with a bad tendency can be punished. Writing a separate occurrence, Justice Louis Brandeis, joined by Justice Oliver Wendell Holmes, argued that restrictions on government action under the First and 14th Amendments do not extend to situations in which speech creates a clear and present danger of an evil outcome. Now, Buck v. Bell really set out to answer if the Virginia statute, which authorized sterilization, denied Buck the right to due process of the law and equal protection of the laws as protected by the 14th Amendment. Carrie Buck was a feeble-minded woman who was committed to a mental institution. Her condition had been present in her family for the last 3 generations. A Virginia law allowed for the sexual sterilization of inmates in institutions to promote the health of the patient and the welfare of society. Before the procedure could be performed, however, a hearing was required to determine whether or not the operation was a wise thing to do. The court found that the statute did not violate the Constitution. Justice Holmes made it clear that Buck's challenge was not upon the medical procedure involved, but on the process of the substantive law. Since sterilization could not occur until a proper hearing had been heard, at which the patient and the guardian would be present, and after the Circuit Court of County and the Supreme Court of Appeals had already reviewed the case, if so requested by the patient. So Nixon v. Herndon. The main question here was the suit properly dismissed for lack of jurisdiction. The plaintiff, L.A. Nixon, was an African American citizen of the United States and Texas who lived in El Paso. He was a registered Democratic voter, and on July 26, 1924, Nixon attempted to vote in a primary election. Based on a Texas statute passed in May 1923 that prevented African Americans from voting, Nixon was unable to vote. He sued the judges of election and argued that the statute violated his 14th and 15th Amendment rights. The defendants motioned for dismissal by arguing that the subject matter of the case was political and therefore did not fall within the jurisdiction of the court. The court granted the motion to dismiss. Justice Oliver Holmes, Jr. delivered the opinion of the unanimous court. The Supreme Court held that while the case may hinge on political action, it deals with private damage, which is always recoverable in a lawsuit. The court also held that the statute in question clearly violates the 14th Amendment. Olmsted v. United States begged the question, does the use of evidence disclosed in wiretap private telephone conversations violate the recorded party's 4th and 5th Amendments? Roy Olmsted was a suspected bootlegger. Without judicial approval, federal agents installed wiretaps in the basement of Olmsted's building, where he maintained an office, and in the streets near his home. Olmsted was convicted with evidence obtained from the wiretaps. The use of wiretap evidence as incriminating evidence did not violate their Fifth Amendment protection against self-incrimination because they were not forcibly or illegally made to conduct those conversations. Instead, the conversations were voluntarily made between the parties and their associates. Moreover, the parties' Fourth Amendment rights were not infringed because mere wiretapping does not constitute a search and seizure under the meaning of the Fourth Amendment. And these are the sources that I used.